Hi, Bill Henshaw here again for the Constitutional Crisis Channel. Today's subject matter is an important one. It'll be corruption in the quote-unquote courts, and you don't need me to tell you how much of that there is. What I wonder is how much of it they come by legitimately, quote-unquote, and how much is exercised because they haven't been taught what the laws are, even in law schools. Can't answer that question at the present time, but I certainly wonder about it from time to time. What my program is designed to do, and you can check all my available documents at ccaspari@live.com that are available, ccaspari@live.com, is to put them in a position where they're going to be forced to obey the oath of office they took to preserve, protect, and defend this Constitution. If they're not willing to do that with the issues that we present, we have more problems to deal with than it would appear like we have at present. But that's what we're trying to do. That's why we go in there with habeas corpus. We go into challenge jurisdiction. We use the subpoenas to get people into court to explain themselves. We put in denial of counsel because that's the only thing they pay attention to, but we can't use their counsel. These are all issues that force the issue, and the issue of state versus territory, which is my primary issue that I use. Now we're going to force them, if they're going to try to defend these, to bring in the 14th Amendment as an affirmative defense to these charges. Once they do that, now the issues we raise cannot possibly be beyond the jurisdiction of their quote-unquote courts. They raised them as a defense. They now can't keep our arguments out, and they can't beat them either. So that's what we're trying to do. Now, how much corruption is there? I wish I had a handle on it. I made a big mistake almost 9 years ago when I got wrongfully terminated from my job, assuming that I could get it back based on the knowledge I then had. I feel much better about it today if this situation were to be repeated. But I simply didn't have a clue how much corruption there is, so be assured that we're up against it. But also be assured, even if you know a little bit of law, you're better off than most of them are, even judges and prosecutors. I remember my first law teacher, by the way, saying that all you had to know about law is that anything that we argued was specious, frivolous, and without merit. That's all they know. Well, later on in this course, in the advanced part, they had a tape came down from the Idaho Supreme Court where he was arguing what we called the Big Three at the time: license, registration, and insurance. Now, we didn't know 30 years ago what we know now about the 14th War Amendment, but nevertheless, they call Mr. Gordon up there, and he speaks for a good 20 or 30 minutes, if not longer, on his issues and trying to get his conviction reversed. And they listen to him respectfully, and his time ends, and he sits down, and they call on the state's attorney to give his side of the issue, and he gets up, and he says Mr. Gordon's issues were specious, frivolous, and without merit. And he sat down. That's all the bastard said. And all he had to say, because the conviction got sustained because we weren't then making the right arguments. But that's all they say because they don't know what else to do. They don't know the law, and they sure as hell can't admit that in open court now, can they? That's a hell of a job qualification, don't you think? You don't know the law, and here you are in a job that says you're supposed to know it. So, this is the kind of stuff that we have to deal with, but I do believe if we use my documents, my issues, and my presentation, we're going to get a hell of a lot farther than we've been able to do to this point. There are issues that they don't see, they don't know what to do with, and if nothing else, it forces them to quietly dismiss your case rather than to take you on. That's not the big result that I want in the end, but it will do for now. Thank you.